Hello, everyone. My name is Stuart Dickman. I'm with Labor Finders, and today we are having our follow-up webinar regarding the FFCRA and additional information about the CARES Act. If you were with us last week, you'll remember that we had Paul Klockenbrink and Kate Huff on. They'll be starting us off today to bring us some of the updates, but we're also joined today by Kristen Church and Gregory Habib, all with Gentry Locke. We've brought you a powerhouse of attorneys, and hopefully they'll be able to answer all your questions. If you do have questions, please use the Q&A button at the bottom of your screen, and we will address those at the end. We have a couple of advanced questions that were submitted in advance, but let's get started. And Paul, why don't you lead us off here?
All right. Thank you, Stuart. Hello, everyone, again. For those who attended last week, nice to see you all, sort of. I know virtually anyways. Again, I'm Paul Klockenbrink, and I'm going to talk just briefly on some of the updates that we've had on the Families First Coronavirus Response Act. And the more important thing is that we have received more guidance. We've also received, if you go online, you can find information from the IRS has provided actually some of the more substantive information in terms of what you have to get from your employees. I'm going to be talking first about just the paid medical leave, the emergency leave, and then Kate's going to talk about the FMLA plus the extended leave. So we've got the regulations. They don't answer all the questions, no surprise, but they answer some of them. We continue to have this law that obviously applies to 500 or fewer employees. And of course, there's also some legislation on that in terms of whether or not you're an integrated employer. I dealt with that issue yesterday under the FMLA and whether or not you then can be above the 500. All right, Kate, if we want to go ahead, we'll go to the next slide. Kate's controlling the PowerPoint here. Okay, so we talked about this last week, and I won't spend, you've all seen these 6 qualifying reasons for paid sick leave. I'm not going to go through each of the 6, individually, other than to address some key points that have been raised or brought to our attention through the guidance, through the information from IRS, and then also just the regs themselves that came out a couple days ago. So with that, I'll go to the next slide. And the reason I'm kind of moving through this quickly, everyone, is we really, today, I think our focus is to give you the information on the CARES Act and to allow Kristen and Greg to really share their knowledge on that. So we're happy to answer questions about the FFCRA afterwards through this. So if you're feeling like we've gone too quickly, keep that in mind. All right, so that first reason that you have for the employee being subject to quarantine or isolation order, this to me actually was one of the more important things because a lot of questions from clients came in on this to say, well, what does this exactly mean? What if the employee just doesn't want to come to work, or say the employee feels like they can't work now for whatever reason because, say, the operation just isn't operating anymore. It could be a restaurant. We had hospitality type people saying, hey, listen, we cannot operate anymore because we just don't have people. So we have to close the doors. That is not equal. If you look down at that third bullet, an employee subject to one of these orders may not take paid leave where the employer simply does not have work for the employee. So that is not a basis for them not to get this emergency leave. They have other opportunities, obviously, to get unemployment. But generally speaking, now this could be different state by state. We realize that there are people in other states listening to this, and obviously the 4 attorneys that are on this line are primarily practicing in Virginia. So a lot of our comments, to the extent they're not federal law based, would be limited to Virginia. But generally what we're talking about is applicable to all the states. So the documentation here is that, you can provide the name of the government entity that issued the order to which the employee is subject. Again, this is one thing that the regs have provided, as well as the IRS guidelines, documentation, what you need. And the reason that can be significant is because if you want to get a tax credit for any of these payments. So that actually is important that you do the documentation correctly. So in any event, can we go to the next slide? I think would be great. All right. Okay. And so this one also is, you have an employee that's been advised by a healthcare provider to self-quarantine. Again, the documentation you get here is the name of the healthcare provider, who advised the employee to self-quarantine for COVID-19 related reasons. We get a lot of questions about, well, can I get a doctor's note? What can I get? Yes, I think the regs don't address that specifically, but we've been advising clients, yes, you can get a doctor's note, but you have to understand it may take some time because some of the healthcare providers are overwhelmed. But again, if the employee can still telework, then there's no paid leave. And this is basically going to be something where, you're going to have to communicate with your employee and find out what's going on. And then, they can't just self-quarantine themselves necessarily. There's got to be some evidence if you want to have it. All right. What's the next one here? Let's see here. Okay. All right. So excuse me one moment. Turn something off here. The joys of working remotely. So, okay. On the third one, this is again, the employee experiencing symptoms of COVID-19 and seeking a medical diagnosis. This one, I would say, is kind of like the first one, was the one that has created, I think, the most angst, because we have employees that are feeling like they're not feeling well, and so they want to take the leave, and they want to know whether they can do it, and they want to be paid. And again, they have to still qualify. Yes, they could have the symptoms, but eventually you can communicate with them to find out whether they tested positive, whether they can still telework and are waiting test results. Because if they're waiting the test results and can still telework, then you can still have them be working, and then they would not have to get paid. Again, you're going to want to get documentation to be able to get to the tax credit. All right, what's the next one here?
Paul, before you skip to the next slide on that one, has there been any guidance or thought to what's a reasonable amount of time for an employee to seek a medical diagnosis? So, I mean, if somebody calls in today, says, hey, I'm not feeling well.
Yeah.
How do you, if I don't classify it as that today, but 3 days go by, their symptoms worsen, they decide to, do a telehealth call or something like that. Now we're into, days 3, 4, 5, maybe. Then if they do get tested, it's another 4 or 5 days. If they test negative, do those 10 days that they may have used now get counted?
Yeah, great question. I would say yes, they're going to count, because if you look at this number 3, experiencing symptoms of COVID and seeking medical diagnosis, it doesn't say you had to diagnose as COVID-19 positive. I think, again, this is a communication situation. We had one the other day where the person said they had an issue, and we find out that they were actually traveling to go out of state to visit somebody, and it came up on Snapchat. So, they were not experiencing symptoms, nor were they seeking medical diagnosis. So I don't know, Kate, any different thoughts you have on that? I think I'll let Kate see if she's got some additional thoughts.
No, I agree with that generally. The person can't just say, I've got some symptoms, I'm self-quarantining. They have to actively be seeking medical treatment, seeking a diagnosis for that. If it ultimately returns negative, that's great. They're probably still going to be eligible for that paid sick leave under this number.
Yeah, and you can, obviously they can look to the CDC guidelines of how long they can be out and symptom-free and so forth. All right, we got on the next one. All right, again, this is the paid sick leave for an employee caring for an individual subject to quarantine order. And again, it's, but for the need to care, but for the need to care for the individual, the employee would be able to work. Again, look at the documentation here on the slides. This is what you're going to want to get. Is there a governmental entity that has issued a quarantine or isolation order to which the individual is subject, and then the healthcare provider is advised the individual to self-quarantine. But there's got to be a genuine need to care for the individual. Anything else on that, Kate? I don't think so.
No, I think generally the regulations show that they anticipate there will be some abuse Of this paid sick leave and of the paid family medical leave, hence the regulation saying there has to be a genuine need. Basically, you can't just say, oh, the buddy I play basketball with is self-quarantining, so I've got to care for that guy, so I'm not coming to work. It's got to be somebody who there would be an expectation that the employee would have to stay home and care for. And again, there's still going to be abuse of this, but I think these are the regs way of trying to handle that.
All right, next one up here. All right, then again, we have the final one that I'm going to address, and we're going to turn it over to Kate entirely on the family medical leave plus, as we call it. The employee here this is number 5, is unable to work because caring for a son or daughter, or because their child's school or place is closed, or the child care is unavailable due to COVID-19 reasons. The questions we're getting on this one is, well, what if, if you've got 2 parents at home, you have an issue of, okay, well, then if one parent can take care of the child, you don't get the double tag team, both parents get to be home. If they are, then that employee's got to be caring for that child. The other thing is, if the child is over 14, then you don't automatically get coverage under this, because you have to actually, if they're 15, 16, or 17, you've got to explain specific circumstances as to why that child needed care. So you've got to provide documentation, name of the child, the name of the school or healthcare, or the daycare center, the child care provider that became unavailable, and a statement that representing that no suitable person other than you is available to care for the child. Again, there's going to be some element of trust here, but those were, if you look at the IRS regs, it gives you some very specific information on this. Again, from the employer standpoint, you're looking at trying to get a tax credit. If you don't have the documentation to support it, that's where you could get caught up. And I think with that, we're going to turn it over to Kate.
Yeah, so there wasn't really anything groundbreaking in the extended family and medical leave regulations. What they did help us to understand is how the paid sick leave and the extended FMLA can work together. Generally speaking, if a person takes, I think it was 4, 5, or 6, the care for another individual, care for a child whose school or daycare is closed, or one of the kind of catch-all other reasons in number 6 for the paid sick leave, they can get the first 2 weeks of this extended FMLA period paid for. Generally, FMLA is unpaid leave. Under this emergency FMLA, it's going to be paid leave for weeks 3 through 12. However, the regulations have made clear that this can run in tandem, and so the person can get the first 2 weeks under the paid sick leave law and receive 2/3 of their salary for that. So it's kind of an interesting thing, because I think the folks at the DOL understood that we were all trying to figure out why have both of these things, because it appears that you're going to get that first 2 weeks of extended FMLA paid if you take the paid sick leave, and that is in fact true. So everybody wanted to know, how do we qualify for this small business exemption? Obviously, this new paid sick leave and paid FMLA is for employers with 500 or fewer employees. That can mean anywhere from 1 to 500. So employers with 50 or fewer employees are not automatically exempt. We did get a question prior to our webinar asking, is an employer with fewer than 50 employees within a 75-mile radius automatically exempt? The answer to that is no. If the employer wants to qualify for an exemption, meaning they do not have to offer this paid sick leave or paid FMLA to employees, they must meet one of these conditions here. Now, nobody's saying exactly what is required for a smaller employer to submit to show whether they meet this exemption or not. But under number 1, for example, you're going to have to show that your expenses, your financial obligations are going to exceed available business revenue if you're offering this paid leave. So there will be employers who have 50 or fewer employees who will not meet this exemption, who will show, no, this actually is not going to be such a financial hardship that we don't have to offer this. The DOL has put it basically up on the employer to keep this documentation and show that it's really going to basically put the business in financial ruin to pay this paid sick leave. What's interesting about this is the Department of Labor says you have to keep all this documentation. You have to show that the denial of the sick leave came from a high-level officer. It wasn't a lower-level person making this decision, but don't send the Department of Labor any documentation. We'll come ask for it if we think you're violating it or we think you're abusing this. With all the documentation, the ones that Paul talked about earlier with the paid sick leave and with this type of documentation for the exemption, the regulations say that the employer has to retain it for a period of 4 years, at least. Of course, you can keep it for more. Generally, and I won't touch on the same things Paul did, but in addition to those specific types of leave, the regs say that all employers need to keep the following documentation for an employee who tries to take this paid sick leave or the FMLA. They want the name, dates for which the leave was requested, the specific COVID-19 qualifying reason, and a statement representing that the employee is unable to work or telework because of the COVID-19 qualifying reason. Now, the telework thing is important because if an employee can telework, then they should not be eligible for any of this paid leave because they can actually work. Now, that means that the employer would have to have telework available for that employee. So that's going to be a fact-specific analysis. But again, this in addition to the documentation Paul talked about earlier, and then the employer has to keep this information for 4 years as well. Now, you don't want me to go into any IRS regs because I'm not a tax lawyer, nor do you want me to be, but these are the types of documents, I pulled this directly from irs.gov, that the government is going to want to see for those employers who are seeking a tax credit for providing this paid leave. So there are specific forms, specific links from irs.gov, and a pretty detailed FAQ section to help employers understand how to get this credit. So with that, I'm going to turn it over to the reason you guys are all here, and that is to hear more about the CARES Act. So Greg and Kristen, take it away.
Thanks, Kate. Thanks, Paul. Thanks, Stuart, for having us. My name is Greg Habib. I'm an attorney at Gentry, Locke. I'm the head of our Government and Regulatory Affairs Practice Group. Kristen is one of our partners who specializes in a lot of corporate issues, and she's been really become the expert on the CARES Act and some of the individual provisions. We're going to run through a PowerPoint here. I can tell you right now, I'm not a believer in PowerPoints with lots of text. So the PowerPoints aren't going to have a lot of information, but even if I was a believer in it, the CARES Act and the payroll protection program that we're primarily going to discuss is changing so fast that any PowerPoint we create, the information will be outdated by the time we presented it. So frankly, everything we say today has a giant caveat to it, which is Congress passed a $2 trillion+ bill a week ago. Since then, we have gotten dribbles and drabs of guidance from the SBA and Treasury, much of which is inconsistent with the actual provisions of the Act. And so if you just read the statute, things look very different than if you just read what SBA and Treasury are putting out. And then we have lenders who are starting to put out loan applications and some of their own spreadsheets to calculate qualifying numbers and that type of thing. And they're all fairly inconsistent. So what I can tell you is for today, we're going to give you the best understanding we know as of now. We're happy to answer any questions. In the chat function, Stuart posted a link to an article we have on our website at gentrylock.com that we are updating every time something new comes out. So every time new guidance comes out, we're updating it. So hopefully that's got sort of the state of the art. But again, it's changing by the minute. For example, I got an email from a bank about half an hour ago that said they were pulling their application process today. They were not prepared. They didn't have the guidance. And they were predicting that other banks were going to do that as well. Some of the big banks like JP Morgan announced yesterday that they were not going live today either. So again, very much a moving target. So let me just sort of orient us on the CARES Act. The CARES Act, the Coronavirus Aid, Relief, and Economic Security Act, actually had lots of provisions in it. There's provisions for individuals. Those are what you've heard called the stimulus checks that are going to be mailed to people. We've heard about some big business funds There's a Treasury Department run $500 billion fund for businesses between 500 and 10,000 employees. Some of you may fall into that category. We're not going to spend any time talking about that. There's some industry specific sort of bailout language in there. There's a provision for small businesses who have already laid off employees. That's essentially a tax credit concept. But all that said, the primary provision of the CARES Act that's getting the most attention is the PPP, the Payroll Protection Program. Again, still lots of uncertainty, still lots of ways this may or may not be following the law, the SBA guidance, but we're going to walk through sort of the best that we can. At a high level, the goal of the PPP is to shove as much money into small business owners' hands as is possible in a short period of time. And the idea at a high level is that the government is going to essentially socialize all payroll costs, overhead, rent, interest on mortgages, and some other things for essentially a 2-month period. So the idea for the government is that if they can give sort of this bridge loan to small business for the next 2 months, then we can all survive. And if we use the money the way the federal government wants us to, again, to keep people retained, to pay rent, to pay interest on debt, then it will convert from a loan into a grant and be forgiven. Kate, you can click the next slide. So let's just sort of talk through each of the things. So the first question everybody asks is who's eligible for the Payroll Protection Program loans? The simple answer is everybody with less than 500 employees. It is a lot more complicated than that once you get into the nuances of it. So normally the SBA has a series of criteria dealing with revenue and employment and other things based on your industry. All of those are suspended for the Payroll Protection Program, just the 500 counts. But there are still some unanswered questions. So one of the unanswered questions is, does the traditional SBA affiliate rule apply to this program? So under the SBA, if you have ownership of small business and you have ownership interest in affiliate companies, you actually have to aggregate your employees under some circumstances. I don't want to go way into the weeds of that, other than to say we don't actually know how the SBA is going to apply the affiliate analysis to the CARES Act, to the PPP loans. And it's important because, for example, one lender that we spoke to yesterday had no questions on their application about affiliates. This morning, they provided an updated application, and it specifically said, do any of the owners of the applying business have an ownership interest in any other businesses? And if so, you need to report the nature of the business, your ownership interest, and the number of employees. And so that could become a big deal for some folks on this call. It is definitely a big deal for some of our other clients who have holding companies with sub companies. Whether they exert control there or not, that may become an issue. So if you are under 500 and have none of these affiliate issues, then you will qualify. If you are under 500 but have some affiliates, we need to dig deeper on that question. And then the caveat to all of that is there are some particular industries that the feds have specifically exempted the affiliate rule from, to hospitality and a few other things. And so keep an eye on that. Kristen, did I say all that part right? Why don't you just leave Kristen unmuted so we can both talk as need be. The affiliate rule, has anything popped, Kristen, just in the last hour on the affiliate rule?
I haven't seen anything come down. I think I checked an hour and a half ago, so it's possible in the last hour something has come down.
Well, this is literally one of those things that's changing by the minute, and it's one of the reasons some of the lenders think they're not ready, because they're not even sure who's eligible because of this affiliate question. So again, we'll keep trying to update folks, and we'll use that website that I posted in the chat function to do that. All right, Kate, you want to bump to the next one? All right, what does the PPP loan provide for my business? So this is sort of the how much can I get question. This is one of the areas where the SBA guidance, the Treasury guidance, differs significantly from the statute. The statutes seem to lay out a way to calculate your loan eligibility that the guidance and the sample application don't comply with. But let's talk about sort of what the statute said, or excuse me, what the guidance and the proposed application say. Essentially what you do is you take your average payroll for 2019. So you add up all your payroll and you average it. But any individual employee whose payroll cost number is over 100 has to be reduced to 100. Included in payroll cost is things like salary, retirement benefits, some health insurance, some state and local taxes that you may or may not pay. So you add all those things up, you divide by your number of employees, you take your average monthly number. There are some huge uncertainties right now in these things. I'll give you just a couple examples. What do you do about federal withholdings? There doesn't seem to be any reason why you wouldn't include federal withholdings, although at least one lender that we've spoken to is trying to exclude federal withholdings. Do you include compensation paid to owners if they're K1 owners of the business? That's unclear. There's been some confusion about payments to independent contractors because of the language in the statute. I think that's been largely clarified, which is that you don't get credit for payments you make to independent contractors, but people who act as independent contractors can on their own apply for a loan. But the point there is that it actually is much more complicated than we thought it was going to be. But at a very high level, if you're doing rough math to figure out what your loan would be, it's all of your payroll costs, salary, health, retirement, all of those for 2019, reduced so that no individual employee is over 100,000, divided by your number of employees, and then taking the average of that over the 12-month period. The most important thing there is getting with your lender and making sure that that you're providing your lender what they need. Once you get the loan, even the terms of the loan are changing significantly. So when the bill passed, it said the loans would be up to 10 years and would be capped at 4% interest. When the initial guidance came out a couple of days ago, it said these were 2-year loans with a 0.5% interest rate. A bunch of the banks complained yesterday, and yesterday via press conference, and then subsequently, I guess, via guidance, the Treasury Department changed the terms of the loan and raised the interest rate from 0.5% to 1%. So, and again, Kristen, correct me if anything has changed just since we've been talking. These are 2-year loans with a 1% fixed interest rate. There's no prepayment penalty. There is a deferral of any payments for 6 months, but your interest begins accruing as soon as you take the loan. And then on the good side, they're totally unsecured, uncollateralized loans. Kristen, yeah, go ahead.
Mnuchin, and in the guidance that issued last night, it looks like the interest begins to accrue as soon as the loan is made, but as long as you get the total principal amount forgiven, that you will also not have to pay that interest that accrued during the period when you spend the funds. And that came through in the guidance, but we're waiting to get some more details on that. And so hopefully that'll be coming shortly. As well, we don't know 100% exactly what the loan terms would be. We know that the maturity date is going to be 2 years. What I've heard is that you're going to have a 6-month deferral within the amortization really over 18 months versus having a balloon at the end of that 2 years for what was deferred during the 6 months. But those are some of the details that we're waiting to see as well.
Yeah, so I mean, literally, again, as you can see, this thing is changing by the minute, and this is incredible that the government is pushing out a multi-trillion-dollar program that's going live today, and some of these sort of fundamental elements of it aren't clear yet. So we'll keep updating you again as we can. We'll talk about the forgiveness thing in just a minute, because ultimately the forgiveness aspect of this loan is maybe the most important side of this whole policy. But Kate, let's click to the next one and just talk about sort of the practicalities of securing a loan at this point. The short answer is nobody has a clue what you actually need to do to secure this loan for your business. Now, we're going to give you some best practices based on what we know as of right now. But again, this is changing very, very quickly. First and foremost, this program is being run through the SBA, so your lender needs to be a 7A certified SBA lender. Most lending institutions either started out as eligible or have attempted to become eligible over the last couple of weeks, but there's no guarantee that the lender you have a relationship with is even qualified for this program. So first and foremost, make sure they are qualified. Second, try to get connected with someone you have an existing relationship with, because it has become very clear there's going to be a rush into this program. And technically, this is a first come, first serve program where when the money is gone, there is no more money. Now, Mnuchin said yesterday, if we run out of money, we're going to go back and get more. Don't worry about it. But that would take additional legislative action. That is not something they can just do. And so you need someone that you have a personal relationship with, hopefully, that can both expedite your application, but also help you get everything that you need. So there are a series of certifications that you have to make in acquiring one of these loans. By statute, it appeared that was going to be the only thing you were going to need to provide. So you were going to need to provide a certification that your business qualifies by size. You were going to have to certify that the uncertainty surrounding coronavirus has led you to seek this loan. There are some additional certifications that have been made. You have to certify that no more than 25% of the loan will be used for non-payroll purposes. You also, and this is where it gets harder, they are asking for a significant amount of information to underpin the certifications and the information you're providing that makes sense from a lending standpoint, from an underwriting standpoint, but was not necessarily clear at the beginning. So all the lenders we've talked to are requiring your full payroll records for 2019 to support the information you're seeking. Tax records are needing to be produced. And certainly on the back end, there's going to be a lot of documentation required. So the steps to acquire a loan are identify a certified lender, connect with them to figure out what they're requiring you to provide, get a copy of both the application, the certifications, as well as their list of documentation. And then you're going to have to do some math on your own. You're going to have to do the calculation that underpins the certification, and then work with your lender. Kristen, did I miss anything there?
No, I don't think so. I was going to say that the relationship with the lender is really important for this program. At least that's what we've seen so far. You'll hear us say repeatedly that we're waiting for final guidance. We're requesting additional clarity. And not, I think, surprisingly, for lenders and banks, that's not a comfortable position for them to be in. And so there have been a number of lenders who have at least said at this point, they do not want to enroll in the program if they're not a current 7A lender. There's a very simple process for most institutions to enroll to be a participating lender, but a number of banks are reluctant to do so, as well as with the low interest rate, the limitation on the bank's ability to kind of vet borrowers. A lot of banks are trying to focus on their existing customer base where they have a familiarity and a comfort level with the borrowers that would be participating in the program. The guidance that came out last night, I believe, was intended to provide some comfort to banks that allowed for some protections and some, safe harbors, the ability for the bank to sell the loan back prior to the end of the 8 weeks. It remains to be seen if what has been provided and what may be provided today will provide banks and lenders with that comfort that they need to really open up the population of lenders. So establishing that relationship or determining whether or not your existing lender is participating in the program is one thing for you to go ahead and do if you've not already done so.
Yeah, and I'll give you an example, and Kristen just sort of hit on this. So in existing SBA programs and some other lending programs that are backed by the government, there's a know your borrower obligation that the lender is required to know their borrower so that if their borrower is committing fraud in obtaining the funds, the bank can identify that. And if the bank doesn't know their borrower, they can sometimes be held responsible for some of the wrongdoing of their borrower. There's no possible way in a program like this, the banks can know their borrowers. And so the banks have said, well, we can't be held responsible to the normal know your borrower standards because there's no way for us to do that. And so it's pretty clear that what the lenders who do step into this and who do begin taking applications are going to be incentivized to prioritize people they have relationships with. So hopefully you have those relationships. If you don't, try to establish them really, really fast. But again, make sure you're talking to a 7A certified lender. All right, we can click the next one. And I think it's the last slide. Yeah, there you go. What can I do with my funding from a PPP loan? Again, the idea is the same categories of expenditure that are used to determine the amount of your loan, are used to determine what you will use the loan for. The whole point is to use your loan for qualifying purposes so that your loan converts from a loan into a forgiven grant. And the feds have made it very clear, the goal is for as much of this money to be forgiven as possible. So this has been a little bit streamlined, I think, by the feds essentially saying you cannot spend any more than 25% on non-payroll related costs. So the idea would be 75% of your loan needs to be used for payroll costs, which includes those same things, salary, some of the benefits, those types of things. There is, in theory, the ability to reduce compensation, but if you reduce the compensation significantly, there's a detriment to you. That's something, that calculation is also a little bit fluid, but if you reduce the payroll portion by more than 25%, so if you cut everybody's pay by 30%, for example, there would be negative ramifications for it. The goal from the feds is to maintain the status quo. So for the next 8 weeks after you get the loan, you pay people the same, you pay your rent the same, you pay your mortgage interest the same. And that if you do that, then that portion will be forgiven. I know that guidance is changing some. Kristen, can you give us sort of the latest on some of those numbers or targets?
Yeah, for purposes of looking at whether or not you've had a reduction in wages, we're still waiting for guidance. The way that the act read, you don't count in that calculation anyone who in 2019 during any pay period made an annualized amount of $100,000 or higher. We haven't received some clarity on exactly what they're going to be looking at as far as covered utilities for that 25% of overhead. So, I mean, questions remain, but from a thumbnail perspective, that's what we're looking at.
And the reality is on all of these things, it doesn't really matter what the statute says. Frankly, it doesn't matter what we say to you today, other than I hope we're giving you some understanding to help you go forward. What matters is what is your lender requiring on the front end in order for you to get the money? And then when the feds issue their forgiveness guidance, which is going to come when we're in the middle of this program, what does it actually say? The most important thing is that you can document everything that you certify, both at the front end and the back end, that you provide your lender with everything that they request, that you provide the government with everything they request. And then, again, these things are changing by the minute. I think that was our last slide. Again, I posted, you can click, I think we have maybe just a generic landing last slide. Yeah, so we gave you all of our contact information. Again, in the chat function is a link to a website where Kristen is keeping everything updated. You'll see there are at least 3 or 4 updates to that page now because each time they issue new guidance, we're throwing stuff up there. And if you have any questions, we're definitely happy to answer them for you, both now or offline. Again, the qualifier is a lot of these things are a moving target. And so we strongly encourage you, if you haven't already, to talk to your lender today and begin this process. So Stuart, thanks. That's what oh, sorry, go ahead, Kristen.
No, I was just going to say, if anyone needs to email me directly, my email is church@gentrylock.com. So.
Yeah, we got a typo there, church@gentrylock. So each one of our emails is our last name @gentrylock.com.
Okay.
All right, Stuart, thanks.
Yeah, a couple of questions though before we go. So for those applying now, will they be grandfathered in under the terms that apply when they ink the app? I think the answer is probably no, because the terms aren't clear yet, right?
Yeah, I mean, again, this is one of those sort of impossible to answer, but we'll give you the best answer we can give you. I don't think loans are going to fund until these terms are solidified, the front end, how to calculate loan terms. So I think the basic terms of the loan, like the interest rate, the prepayment, lack of prepayment penalty, the maturity, those things are probably pretty set now. But they're not going to, I don't think they're going to fund any of these until those terms are 100% finalized.
And when you submit the application, at least the revised application that was posted last night by the Department of Treasury and the SBA, when you are certifying as an applicant, you are effectively certifying that everything is correct and you're eligible as the instructions exist at the moment that you submit the application, with the recognition that there continues to be potential, changes in guidance. Only one application can be submitted, so you can only have one PPP covered loan. So that's one thing to think about. Most people will want to borrow the maximum loan amount they're eligible for.
Stuart, one thing we didn't get into, and I see a question from Ronald Bragg on there that's kind of getting to it. So let me touch on this. The PPP loans interplay with a lot of the other programs. So for example, if you already took one of the emergency disaster loans, there's a provision for converting that in theory to one of these PPP loans. But the other thing that's relevant, and this is what the question was if you have employees who are receiving unemployment before you receive the loan. So keep in mind, one of the other things that this law did is it added up to $600 a week in unemployment benefit to the existing cap in each state. So you may have employees who either you've already laid off or who have chosen to go into unemployment because it's to their financial benefit under the circumstances, whatever. There's actually a provision in the PPP to recall workers essentially if they were laid off. And Kristen, is the date February 15th?
If you laid someone off, I believe it was from February 15th through April 26th. And then you won't be penalized if you bring up your employee levels, full-time equivalent employee levels by June 30th. So for purposes of forgiveness, when you're doing your count of employees during the covered period and you're comparing it to a historic window in time that the government gives you, you won't be penalized if you have a reduction that you cure by June 30. The tricky piece of that is you would still need to be able to utilize the funds received under the covered loan for covered purposes, including 75% or more of those funds for payroll costs during that 8-week measurement period in order to be eligible for 100% of forgiveness. To the extent that you're not eligible for 100% forgiveness, the unforgiven portion would roll forward as a loan, again, with the same interest rate and maturity date. But those are some of the details that you have to look at. But there is an incentive to rehire or hire folks to bring your employee levels back up.
Yeah, so let's look at maybe a real simple real world example. Let's say you had 10 employees last year and the employee's average payroll cost was $1,000 a month, okay? So your loan you're eligible for is 10 employees times 1,000 a month, 10,000 times 2.5, because that's the multiplier. Let's say since then you've laid a bunch of those people off. So your eligibility for your loan is determined by your 2019 numbers, but your eligibility for forgiveness is determined by how you spend that money. So if you've laid those people off, again, between that window, that February to April window, if you recall those people and then use the money to pay them, then it can become forgiven. Now, there's a tactical decision you have to make in there, and your employees have to make a decision because now they might already be getting the enhanced unemployment benefit. They may not want to come back. If you think, well, all I'm going to do is pay them for 2 months and lay them off again, you may decide you don't want to do that. But that's a scenario where you calculate your loan based on a multiplier for 2019 payroll. You calculate your forgiveness based on how you actually use that money so you can recall employees in that window. Hopefully that wasn't too much nonsense, Stuart.
No, I got you. So I have a question that's very similar to what Tara Phillip just submitted. Is there a central place to apply online with SBA or only through your direct banks? And the second part of that is I have spoken to a couple of business owners who did apply through SBA online earlier in the week. And do you anticipate that those applications will just be lost forever and the process is going to have to go direct with a lender?
Yeah, I'm not actually sure how anybody applied through the SBA earlier this week. I don't believe that existed.
It was probably the economic disaster loans that you could apply for directly through the SBA.
Yeah, and there's a lot of confusion of those. So that economic disaster loan was a different program in a different bill that predated this program, and those were loans. Once Virginia, for example, or your state got the certification of a disaster, then you were eligible for those loans. There is no process by which you can apply directly to the SBA for the PPP loans under the CARES Act. Those are purely run through SBA certified lenders. The SBA, you can go to the SBA site to get the guidance. You can go to the SBA to get a sample application. You can go to the SBA to get the list of lenders who you can use, but all applications have to go through a bank.
So are the terms for the economic injury disaster loans, are those clear at this point?
So we haven't spent a whole lot of time studying that one. Kristen may be able to jump in with the terms. I will tell you eligibility is different there because you have to make certain certifications of harm to your business. And so whereas this loan is sort of available to everybody that meets the size threshold, those are different qualifying loans.
That's right. And I haven't studied that specific loan program extensively other than to look at the interplay with the PPP loan program. If you have received an economic injury disaster loan, the application, the sample application for the PPP loan contemplates particularly the 10,000 kind of immediate funds that you can receive, including that in the calculations. You cannot have both loans that you're using for the same purpose. That's not to say that if you have an idle loan that you are prohibited from participating in the PPP loan program. It's just something that if that's a situation that applies to you, you need to make sure that you're very clear on the rules and how they're going to impact your application for the PPP loan, requesting forgiveness, as well as your existing or pending idle loan.
Okay.
Yep.
Now, today was the opening date, if you will, for most companies, but there's a future opening date for sole proprietors and independent contractors. Can you talk about that a little bit and maybe what you're hearing as far as the differences and how that may apply to businesses that are sole proprietors or LLCs with no employees?
Yeah, and I think this is what caused some of the confusion in how you calculate independent contractors. I mean, this reference to somebody as an independent contractor is not really an employment status. You're whatever business you are, you act as an independent contractor. But yes, and Chris, I'm gonna let you jump in and talk about how the PPP is the timing issue. But they've said that, quote, sole proprietors and, quote, independent contractors are also eligible, but they apply. It opens for them next week. Kristen?
Yeah, it looks like the application that was posted last night, it clearly is going to be the same one that would be used for sole proprietors. And it is a week delay. Now it's unclear what funds will be available, if all of the funds will have been kind of taken by that point. There was nothing in the guidance, at least so far, that would have a set aside or any priority for sole proprietorships. For independent contractors or self-employed. So it is going to be interesting to see exactly what happens, but that really did add to some of the confusion because some of the terms in the act and in some of the guidance that's issued since then has been very unclear, and it will differ whether you're talking about an individual or an entity. And so I'm like all lenders, I'm looking forward to actually clarifying guidance. I would love to see hundreds of pages of regulation that actually lay out all of the scenarios and answer all of the ambiguity and provide clarity.
And it's your understanding that the $358 billion, it's one bucket, regardless of the delayed application process, right?
Correct.
Yes.
There's actually a couple of small categories in there. It's 349 and then there's a 17, but it all is one thing. I think, and this is a dumb thing to do, to try to say what you think the feds were trying to do. I think that independent contractor, sole proprietor thing is really trying to get at gig workers and is trying to identify those people who are in the gig economy or the individual providing services economy. And so the priority is given to people who are paying their employees, and then people who have individually lost money that they would have otherwise gotten, they're the second tranche of money.
Okay. And how about the $10,000, even if denied portion of the loan process? Is that under the EIDL only, or is that also the PPP?
So there's a provision in the CARES Act. It's not in the PPP, which is a sub within the CARES Act. There's a provision that if you've suffered a certain amount of harm to your business, and that's based on revenue reduction or number of employee reduction, then you can get essentially a payroll tax credit, I think is the way it's being structured. And that's the newest sort of $10,000 grant that's in there, which is separate from the disaster grants. And I've had one client ask me about that program in the CARES Act, and we've given some sort of high level stuff on it. I haven't dug into the nuances of qualifications other than you have to show, quote, substantial harm to your business.
I think, isn't there a provision though that even if you apply for one of the loans and get denied though? My understanding is that there's a 10,000, you're going to get the.
You can get the $10,000, and I think that is contemplated, at least that credit is contemplated in the PPP application where you're discussing about you can't get the $10,000 that you may not qualify for and get the full amount of the PPP. So I think part of the issue is the government is still trying to get their hands around really the interplay of these multiple programs and making sure that they all play well together and people aren't being penalized for using one that they should be able to use with another, and they're also not able to double dip. And so we're seeing additional clarity coming down from the government in the instructions that are being provided now on like a daily or sometimes multiple times a day basis. And before we kind of end, I wanted to make sure that we clarified with the dates for application. Sole proprietorships are treated the same as small businesses, so they can actually start applying today as soon as your lender will start accepting applications and processing them. The April 10th date is for independent contractors and self-employed individuals. And again, we don't have like a specific definition of that and what the difference is between an independent contractor and self-employed individual versus a sole proprietor who has, there's just a lot of uncertainty, but at least that's what they're saying.
Yeah, I mean, in my mind, if you are an individual who is you just do your own business, you are self-employed, you are a sole proprietor, and you may act as an independent contractor. So this is what happens when you draft a 1,000-page bill in a day or two and then issue guidance within, a few days after that. Stuart, I see there's a question about unemployment funds and whether or not people should seek unemployment funds. And we kind of touched on that. That's frankly sort of a tactical question. It's not necessarily, it's really math. I'll tell you the one client I have advised who owns a series of salons that closed and laid off essentially everybody. And his question is, do I bring people back and take a PPP loan, or do I tell them, take the enhanced unemployment benefits you can get? As much as he wants to bring them back, unless he thinks his business will be back up and running in 2 months, it doesn't actually make a whole lot of sense for him because he's going to relay these people off. And so I think he's going to take a PPP loan based just upon the number of people he kept employed. And he's going to tell his already on unemployment folks that they should continue down that path.
How about people, and I know you maybe only be able to speak to Virginia, but for people that either are having their pay cut or are seeing a substantial drop in their income due to commissions as a result of business slowing in general, can they apply for unemployment for the gap there? And specifically commission related.
Yeah, so I'm not an unemployment lawyer to answer the nuances of qualification for unemployment law. I can tell you that if you are one of those people, so you're in a status where you're commission compensated, you still should be able to fit into the PPP provisions to keep those, to make however you're ultimately compensated, whether it's your commission in a sole proprietorship or you're affiliated with a business that pays you commissions, there still should be a PPP provision that would apply. Kristen, have you looked at the unemployment rules as they change related to commission workers?
No, other than just the references in the PPP program regarding how to, that there will be guidance as far as calculating and paying out for folks who had commission in 2019, but may have lower commission numbers in 2020. But again, that's waiting to be seen, but I'm not sure if Paul or Kate have looked at the unemployment aspect.
Okay. We have a question related to the FFCRA, the 80 hours. Can it be used all at once? Or I'm sorry, does it have to be used all at once, or can it be used 5 days feeling like they have symptoms, it turns out they don't, and then maybe a month later they truly get the virus and use the remaining 5 days? believe the
Yeah.
answer is yes.
The answer is yes. Yeah, it's just a total of 80 hours of paid leave, and it can be used just like FMLA. It can be intermittent. It can be all at once, just depending upon the circumstances.
Okay. And guys, I think you can see the last one. I don't know if you can answer that as it relates to a Maryland small business, but the loan that I applied for was the Maryland Small Business COVID-19 Emergency Grant and Loan Programs. Is this different from what we were discussing today as it relates to the PPP?
It likely is. There are a number of grants and other programs that in response to the pandemic have been unrolled at state and local levels. And so I've not heard of that specifically, but it doesn't sound like the two that I'm primarily familiar with, which is the economic injury loan that's also through the SBA directly, or the PPP. For the federal programs, if you go to the SBA.gov website, they actually have a aggregated page of COVID related programs that the SBA has involvement in. And so that's a good way to get at least an overview of SBA federal programs that are currently in existence related to COVID-19 and the government response.
Yeah, and I would encourage you, I mean, even at the locality level, for example, I live in Richmond, Virginia. Richmond has an economic development authority. Richmond announced yesterday that their EDA was creating a $1 million grant fund for local businesses that they could apply for grants. So literally at the local, the state, and the federal level, there are now programs. So you should be exploring all of these based on where you live. So far, the feds have not said that acquiring any of those other sources will affect your eligibility on the PPP, unless the other federal sources relate to your PPP, but not, so far I don't think they've given any guidance that applying for state or local would disqualify you or reduce you in any way.
Okay. And we'll make this the last question. It's also an employment related. If you're providing work share to your employees, will they still receive the full 600 each week for the partial hours they're claiming? I think the answer to that is any unemployment benefit issued by the state is supplemented by the $600.
Yeah, and keep in mind, the feds aren't saying you get $600 more dollars. What the feds are saying is they're adding to what the states provide to increase the maximum somebody is eligible for. So you still are only eligible for what you're eligible for, but I think the Virginia maximum was $338 a week, something like that. There's now a supplement to that, so you can get up to essentially $900 a week. It doesn't mean you will get that amount. It means that's the maximum amount you're eligible for. The eligibility questions are still the same, whether or not a partial reduction qualifies you or not. This just reduces the maximum you can get. So
that's a very different view than everything I've understood. So my understanding was that they didn't. I don't know if you are or not. So anybody else have an opinion on that one? Because that's very different. My understanding was that they blanketed the 600 because the states with their antiquated software didn't have a way to distinguish variable amounts based on that. So therefore it was just 600 plus the state benefit.
So I'm only dealing with Virginia folks, and everyone at the Virginia state level that I talk to at the unemployment folks have not described it that way, but maybe that's the way it's going to work out. Frankly, I haven't talked to anybody since last week about this, but their interpretation when the bill passed was it was just going to raise the eligibility threshold. But again, this isn't something I've dealt with since the bill actually passed.
Okay, well, that's something that we'll try to dig into, and if we can find an answer, we'll let the people that have registered know. So, okay, well, that's it. I think we'll wrap it up here. And again, if you registered and you're on the call, we'll send out a copy of the recording as well as the slides, and we appreciate it. And keep in mind the link that Greg posted to their website. They'll be updating that as things happen. So appreciate it, guys. Thank you very much.
Thanks.
Thank you.
Thank you.
Bye-bye.